Hi, this is Armando Roman with AXIOM Founders Family Office in Scottsdale this morning, here today with Richard Keyt of Keyt Law, an estate planning law firm here in Scottsdale, Arizona. Richard, how are you doing?
Good. How are you doing this morning, Armando?
Good. Doing great. Hey, Richard, I realize the expertise you have, and we rely on you for our clients and for questions that we have along the way. But a lot of people just don't really understand what estate planning is, what those basic documents are. So I'll give you a second, if you wouldn't mind, just to introduce yourself, and then I'll just ask you a bunch of questions about what you do, if that's okay.
Yeah, that sounds great. So as Armando said, my name is Richard Keyt. I am an estate planning attorney here in Phoenix or Scottsdale, Arizona. I have been practicing now for about 10 years. And prior to entering the legal field, I was a certified public accountant for a few years.
Wow, fantastic. Well, that's great experience that you bring that CPA experience into estate planning. I'm sure it gives you a different perspective than maybe some of your colleagues. So, Richard, just let me ask you some basic questions. When people think about estate planning, they probably don't know really what to think. So I wrote some questions down to ask you here. But what is an estate plan, and why is it important to have an estate plan?
Yeah, so that's a great question. A lot of times there's misunderstanding about what an estate plan is. But ultimately, an estate plan is a plan that you create that provides what you want to happen in the event you become either incapacitated, and then what happens when you die.
Okay, so incapacitated, that's a long word with a lot of syllables. What does that really mean, incapacitated?
That means essentially that you're no longer to take care of your affairs, both from a health and welfare standpoint and from a financial standpoint.
Okay, so when I think about incapacitated, what it makes me think of is maybe, I often will think about an older person, maybe they've got some Alzheimer, or maybe they've got some dementia, but they've got something that does not put them in a place where they really can make decisions for themselves and really take care of themselves. That's what you're talking about with incapacitated, right?
That is correct. And, it doesn't always necessarily mean that the person doesn't understand or they have some sort of health issue where they don't realize what they're doing anymore. But it could just be also those scenarios that arise when somebody is just not willing or able to do it anymore because they're older, tired, and it's just a lot of work for them to manage and stress for them to deal with at that stage of their life.
Yeah, that makes sense. I'm glad you brought that up, because just recently in the last year, a friend of my son who's 25 years old was in a car accident and was in the hospital for several weeks, and couldn't really, physically couldn't do anything because it was a pretty serious car accident. And luckily he's on the road to pretty much 100% recovery. But these documents that you're talking about and incapacitated, that would also apply to a 25-year-old, to this guy who was in the car crash, right?
Yeah, it would definitely apply to him. And without any documents in place, what normally happens is a court needs to appoint what we call a guardian in Arizona to make those health decisions for him if he does not have a healthcare power of attorney.
Okay, and I'm sure this young guy didn't have any of those documents, because when you're young, you feel somewhat invincible and like it's not going to happen to you. But given that, someone who that age maybe doesn't have those documents, would it by default mean that maybe his mother could step in, or a sibling? And
Yeah, generally speaking, there is a list of people who have priority to make decisions in that situation. So depending on what happened and how his condition was when he was admitted to the hospital, it may be that he could sign those documents at that point in time if he understood what he was signing and what he was doing. But if he didn't have that ability to do so and he was completely incapacitated, then there would have to be somebody appointed to make those decisions for him. And the state would determine who has priority. Now, sometimes it could be there are people with equal priority. So if his mother was his only living parent, she would have the authority to do so, but she would have to go through that court process to become appointed as his guardian. If it was siblings and the siblings didn't necessarily agree on who should make those decisions, and that's where you get into messy situations.
And I imagine that,
Yeah, the common scenario was the Terry Schiavo incident that occurred. It's been a while now, I think 20 years ago, where each side of the family was fighting over who made decisions for her.
right. It just drives home the point that it's in the person's in everyone's best interest to have some documents in place so they don't get in that same position.
Yeah.
Okay. And so Richard, a pretty basic question. Why would I need an estate plan?
Yeah, everybody needs to have an estate plan, even if you don't have what you consider substantial wealth to give away, because you want to make sure that the people that you trust the most are making decisions for you when you're in a vulnerable state and not entirely with it. If you don't have those documents in place, you're kind of rolling the dice and hoping everything goes well. But by having the estate plan and the corresponding estate planning documents, you can be assured that people that you trust to manage your affairs will do so and to your benefit.
Okay. Okay. And the basic estate documents, what's in when someone comes to you for the first time, they've never done any estate planning, what should they expect will be part of that process and part of their takeaways once they're done working with you to get those documents put together?
Yeah, so the first thing we want to discover is just where you're at in your life. You know, what's your family situation, what your financial situation looks like, and what your ultimate goals and hopes are in creating this estate plan, and what you're looking to set up to benefit not only yourself, but then your family in the future if something were to happen to you and you were to pass away.
So then, you hear about wills and trusts, and it all kind of sounds a little bit vague. But you're the attorney that creates this and interprets this and writes these things out. What are those basic documents that go into that estate planning process?
So the will and the trust, those are two types of instruments that are used to transfer property after the death of the person who creates either a will or a trust.
Okay.
A will is a document that provides when you die, any assets that are subject to probate would have to be administered and overseen by a court in either the residence or either in the state where the decedent died or in any state where the deceased had property. So in that scenario, a person would submit the will to the court. The court would determine that the will is valid, and then they would appoint what we call in Arizona a personal representative to collect all of the assets of the estate, pay off all of the deceased person's debts and obligations, and then distribute those assets under the terms of the will. And then after that's done, they would close the estate, and that is the probate process in a very general nutshell. Now, the difference with a trust is a document that's created while you're living and funded with your assets during your lifetime. So
Okay.
the purpose in funding that trust during your lifetime is to provide that when you die, those assets can be distributed right away without the need to go through the probate process. So it saves your family some time and expense, and it's not a public proceeding as well. So there's some privacy elements that go along with trust as well.
Okay. And it sounds like also, if someone has unexpectedly passed away and the family is grieving, having to go through this whole process just seems like it would extend, not the grieving, but certainly extend everything so that the healing has to begin later.
Yeah, so with the probate process, it can lead to stressful situations because, you hear horror stories on the television and the radio and so on and so forth. So people believe that now they're going to have to go through this ugly court proceeding to distribute the assets of their loved one's estate, and there could be acrimony between the family. There could be pressing issues that they need to be dealt with right away. So there's all these different factors and scenarios that cause angst over the probate process that can usually be avoided with the trust. The trust provides those people with some peace of mind that they don't have to deal with probate in the first place. So that's another added benefit of having a trust in place.
Okay. I spoke with someone last week, Richard, who I hadn't spoken with in a while. He's got 8 kids now from 4 different women. And I don't believe he's married at this time. Maybe he is. But I remember asking him about estate documents and estate planning, and he had none of that. He had none of that. And to me, it just sounded like a great big fight. If during his lifetime, he doesn't get some of those things nailed down, it just leaves the kids and the moms of those kids in a situation that doesn't really help anybody. It seems.
Yeah, that's not a good scenario, because if something were to happen to him, he's going to have to, his family members, so, the mothers of his children are going to have to work together through the probate process to determine how the estate would be distributed and managed. Now, if he's somebody who has a lot of money, that situation is not, it's going to be difficult to get somebody appointed personal representative. And it kind of reminds me of another case that I had that went through probate, where we were dealing with a minor child. And because the child doesn't have the capacity to sign legal documents, a bond needs to be posted, which serves as a form of insurance to make sure that the personal representative carries out the duties and the assets get properly distributed to the heirs. So that bond can cost a certain percentage of the total value of the gross estate. Causes the personal representative to have to put forward maybe tens of thousands of dollars to get appointed, and then ultimately you're going to have to get conservatorship set up for each of those minor children, which are difficult to administer on an annual basis and expensive. So
wow.
In those scenarios, you definitely need to have a trust in place to make things easier and less expensive.
Okay. So a question for you, a will, we hear about a will, and when you think about a will, I'm sure you think of all kinds of legal things that need to be in there to make it valid and all that. But what is a will for someone who does not have a will yet, and they need to go through that process, or maybe they haven't updated the documents in, say, 20 years? What should they be thinking about in that will that matters when they talk with you, so that you can really help them get that will nailed down for them?
Yeah, there's 3 things that need to be in a will. And the third it depends on whether or not the person creating the will has minor children. So the first thing that needs to be in the will, it has to designate who you want to administer the estate. So that's the person who would be in charge of collecting all the assets, paying all the debts, and then distributing everything to the people designated in the will to inherit the property. So in Arizona, we call that person a personal representative. It's also commonly referred to as an executor. So that's the first element. The second element then is, who do you want to inherit your property?
Okay.
Go to your kids? Do you want it to go to other family members, charity? So that's the second element. And then the third element would be, if you have minor children, who do you want to be their guardian if something were to happen to you?
And the guardian steps in the shoes of the parent until that child becomes
18 years old and of legal age to manage their own affairs.
Okay. Okay. And a will, who should, once you get a will done, where should that document go? Who should have copies of that document?
Ideally, the person who creates the will should have the document and then the original document, and provide the personal representative with the location of the original will. And then, anybody that you've designated to act as your personal representative, the first person you've designated, and then all the alternates should have a copy as well.
Okay. So sometimes, wills are contested, and sometimes people will maybe come to you, do documents, and then maybe later they handwrite something different, or they tell someone something that is not really part of the will. And I remember somebody asking me once, a long time ago, that if they wrote their will just on a napkin in a barn and somebody witnessed it, is that valid?
Yeah, that is what we call a holographic will. And in order to be valid in Arizona, so a holographic will is a handwritten will.
Okay.
In order for it to be valid, all you need to do, or all the person creating the will, which we call the testator, needs to do, is write it in their own handwriting, and it must be the dispositive provision. So what I mean by that is who is acting as the personal representative, who is receiving the assets, and then it needs to be signed and dated by the testator. It doesn't even need to be witnessed. It just needs to be in the testator's handwriting. The important provisions of the will need to be in the testator's handwriting, and then it needs to be signed and dated.
Wow. Huh. Okay. Wow. I didn't realize that's how that worked.
Yeah, when when it's done on a typewritten will and whatnot, it can get messy on whether the handwritten, what we would call codicil, is valid. And yeah, it gets messy. The long story is, don't handwrite things on your
So you touched on, or you mentioned probate. What is probate? How does that work?
Yeah, probate is the legal process, like I said earlier, where a court would determine whether a will is valid. And then if they do determine it's valid, they're going to appoint the person named in the will as the personal representative. And then once that person is appointed personal representative, the court will issue them a document in Arizona that we call letters of personal representative. It's also commonly referred to as letters of testamentary. So that's the document that the personal representative would give to banks, title companies, third parties, to show that they're authorized to act on behalf of the estate.
Okay. Okay.
Probate may also arise in a scenario where a person doesn't have a will. And in that situation, what we refer to that as an intestate estate. So that means that the person died without a will. That's what intestate means. And in that scenario, the state has essentially its own estate plan for the deceased person. And that relates to both who receives the assets and who can act as personal representative. So at that point in time, the state would determine how your estate is administered, who receives it, and who administers it.
Okay. So you mentioned about validating the will. Once the court validates the will, then the personal representative that's mentioned is the one who's appointed. But I'm really curious, how do they validate? And I'm thinking about a family I spoke with years ago. It had an elderly aunt as part of the family. She had some significant assets, and in her last few years of life, she was meeting fairly regularly with her estate lawyer. The estate lawyer videotaped those meetings because he was a little bit concerned that the will and estate documents might be contested after she passed. So he didn't want anyone to think that she was not able to make decisions on her own, that she was fully capable to make decisions, and that. So he was videotaping the meetings he had with her. So when a court typically validates a will, what's the normal process that the court uses to validate?
Yeah, it depends on a number of things. The first thing is, how was the will created? So if the will was signed by the testator, that's the person who creates the will, there were two people that witnessed the testator signing the will, and everybody's signature is notarized, and then that originally signed will is submitted to the court, that can go through what we call informal probate. So once that will is submitted to the court, the probate register here in Maricopa County will take a day or two to make sure that everything is correct in the will and the probate application that's submitted. And then they'll typically just rubber stamp it and give it back and appoint the person that's designated in the will to act as personal representative. Now, what that personal representative will have to do is give notice to all the interested parties that they've been appointed personal representative, and that those interested parties, if they don't agree that the will is valid or that there's something wrong or that the person shouldn't act as personal representative, then they have 4 months from the date that notification goes out to challenge that person's appointment. So that's in the context if the person still has the original will, or that the will is self-proving, which means that all the signatures are signed and notarized with respect to both the testator and the two witnesses. Now, if the will doesn't meet those requirements, then it has to go through what we call formal probate. And in the formal probate process, a court hearing is required to determine the validity of the will and whether or not the person seeking appointment should be appointed as the personal representative. So in that scenario, you would have a hearing before a judge. The judge would make you notify all of the interested parties, and then you would show up to the hearing, typically about a month and a half after all the documentation is submitted. And the judge would ask if anybody objects to the will being admitted to probate, and if they object to the appointment of the personal representative. Now, if somebody objects, then you have a contested probate, and you're talking about litigation over the issues that the parties can't resolve.
Wow.
Nobody objects, the judge will usually accept the will, appoint the personal representative, and then the administration continues forward just as though it was an informal probate.
Okay, so that just really kind of drills home the point that you really want to get these documents done and get them, witnessed, notarized, filed, put in the right places. Otherwise, it sounds like it could really drag out into an expensive, time-consuming, stressful thing to have to go through.
And one other thing though, Armando, with probate and creating a will, just because you create a will doesn't mean that the assets of your estate will go through probate. So if you do create a will, what we would advise people to do is to set up the assets that they own to pass to their heirs through what we call a transfer on death designation
Right.
or a pay on death designation. So that's a form that you can fill out with your bank, your brokerage account, your IRA accounts, 401k accounts. So you can designate who you want to inherit those assets on your death. And those assets will pass to those people without having to go through the probate process. And that's regardless of what your will says. The purpose of the will then is a form of insurance to make sure that if you forgot to do a transfer on death or a pay on death designation, that whatever asset may be subject to probate still goes to the respective individuals that you want to inherit it.
So if somebody, you mentioned beneficiary on, say, an IRA, a 401k, or any kind of a account that lists a beneficiary, and this is not that uncommon for someone to have a second marriage or maybe a third marriage, but in the case of, say, a second marriage, if they had that 401k with their employer and named their first wife as beneficiary and did not change it, even though the documents were updated in the will, and that for the new wife, the second wife, if they don't go back and change the beneficiary, then that beneficiary, that is what determines who gets that account, right? Or no?
Not in Arizona. Arizona has a statute that says if there's a divorce, then that person is disinherited from any testamentary instrument. Now, I'm not exactly certain in your scenario. I would need to do a little research, but there is a statute in Arizona that provides that on the divorce of a person, any gift or device that's left to that person in a will, transfer on death instrument is no longer valid. But regardless, if that happens, that you need to update those documents so you don't get into that scenario where you're having to push for that in court.
Right. And when people change jobs, it's easy to forget about that old 401k and the old beneficiary designations and that. But it's just important for someone when they're meeting with you to, when they list all those assets, that they don't forget about those old accounts and get those beneficiaries to where they really want them to be.
And I'd add along those lines too, it's important that people create a list of things that they own so their family knows where to look for things and nothing gets overlooked. I mean, we've seen before that people have discovered that, their parents or whoever it may be had large insurance policies that they didn't know about. And so things do get overlooked, and it's important to keep a list so your family and loved ones know what you have and where it's located.
Okay, good. So one last question about the probate process. That sounds like it could be a very expensive process. Is it a costly process? Does it depend on all the things that are involved in that?
Yeah, it depends on a number of things, but generally speaking, if the family gets along, they have documents in place, it's not as scary as it's made out to be on the news or the radio. We could do a simple informal probate here for $3,500 to $5,000, which is usually roughly the cost of preparing a trust or a trust-based estate plan during the person's life.
Okay. So probate and the trust, how does a trust help either avoiding probate or making probate less less onerous on the surviving members of that family.
So with the trust, on the death of the person who creates the trust, the person no longer has any assets that they own. Those assets will be owned by the trust if we assume that during the deceased person's lifetime, they funded their trust, which means they changed ownership of all their assets from themselves into whatever they name their trust. Now, in the trust agreement itself, it will provide for a successor trustee. And the successor trustee is similar to a personal representative, but it applies to the trust agreement. So the successor trustee would be responsible for administering the trust according to the terms of the trust and making sure those assets get distributed to the beneficiaries who are named in the trust agreement.
Okay. Okay. So in a trust, I think you mentioned before to me in other conversations, there are really three parts to that trust. You know, the person who created it, who's going to receive those assets. Can you talk about that, please?
Yeah, a trust is basically a contract among three parties. The person who creates the trust, and that person we refer to as a trust maker. They can also be referred to as a grantor, a settlor, or a trustor. So those are some other terms for the person who actually creates the trust. So they create the trust, and then they give the property of the trust, so the assets of the trust, to a trustee. So the trustee holds title to those assets, meaning the trustee has the authority to sell those assets, invest those assets, buy other assets, borrow against those assets. So the trustee will have power over the assets of the trust. And then the third party is the beneficiary or beneficiaries. So the trustee must use those assets for the benefit of the people who are designated as beneficiaries, meaning the beneficiaries will get the enjoyment of the trust assets according to the terms that the trustor or the trust maker wanted in the trust agreement.
Okay. And Richard, one thing that I will hear from people sometimes when they haven't gone through the estate planning process is they're reluctant to create a trust because they think they're giving away all their assets and they're losing control. Maybe you could touch on that?
Yeah, that's a good question. So in the common revocable trust, so revocable means that the trust can be changed, amended, terminated at any time during the trust maker's lifetime.
Okay.
And along those same lines, the trust maker is also the trustee and the beneficiary of the trust they create. So they're not giving up control. They're just basically creating a legal fiction for the purposes of planning for their estate, meaning if they become incapacitated, then at that point, legally they'd give up control because the successor trustee would come in and manage those assets.
Yeah.
Have to still do so for the benefit of the trust maker. If they don't, then the trustee can be held legally liable. So you're not giving up control, you're just creating this legal fiction to make it easier to manage your estate, both during your lifetime and after you die.
Yeah. So the term legal fiction makes me laugh because it just sounds like a real odd term. But I think, and correct me if I'm wrong, but I think what you're saying is that when that person creates that trust, they still own those assets, they still control those assets, but it sits there titled in this trust, but it doesn't really kick in until one of those two things, either they die or they become incapacitated. Is that right?
Yeah, so they have the ability to change the trust, get rid of it, do whatever they want with it, up until the point in time they become incapacitated. or if they never become incapacitated when they die.
Okay. Okay, so they can still have control of that. Okay, great. So a couple more questions for you here. You mentioned about payable on death and transfer on death. So that would apply to things like bank accounts, brokerage and investment accounts. That's where the bank or the investment, the custodian, et cetera, they could say, this is for this is, say, Armando's IRA, or say Armando's brokerage account, payable on death to my wife or to my kids, right? So it's actually in the title, and then that gives the directions or instructions to whoever is holding that account, so that if and when I die, not if, but when I die, then that would in fact transfer as I've indicated in the title of that, right?
Correct. Yep. So what happens when you die, your wife would have to take a copy of your death certificate to the custodian, and then the custodian would retitle that account into the name of your wife.
Okay. Okay. All right, good. And then what about a beneficiary deed? What is that? How does that work?
A beneficiary deed is a transfer of real estate upon the death of the real estate owner. So it's the equivalent of a transfer on death or pay on death form that you would file with your bank, except with the beneficiary deed, it gets signed, notarized, and recorded in the county where the real estate is located. So then what the beneficiary deed would provide for is who inherits that property on the death of the property owner. And then the benefit of the beneficiary deed is it doesn't go through probate. It gets transferred to the beneficiaries listed in the deed on the death of the property owner. Avoids probate. So it's a useful tool to avoid probate for real estate in Arizona.
Okay. So that's really for your primary residence?
It could be for any property. Yeah, it could be for your primary residence. It could be for a vacation home, investment property, although not recommended, but it could be for any real property in Arizona.
Okay, so any real estate type property?
Mm-hmm.
Okay. All right, good. All right. So when people are thinking about a trust and whether they should or should not create one, what should they be thinking about so that they communicate with you and tell you all the information you need so you can help them decide if they really need a trust or not?
Yeah, the first thing I would consider is, do they have minor children? And if they do have minor children, do they have sufficient assets that are used to care for the minor children if something were to happen to both of them? The benefit to setting up a trust in that scenario is probate avoidance and ease of administration, because now if something unfortunately were to happen, the trust is in place from the beginning and it can be used to provide funds to care for those children right away, rather than having to rely on a will and go through the probate process. And you can just avoid that entirely. So that would be one scenario. Another scenario is if they have family members or loved ones who they wish to protect, meaning you may have a family member who's not very good with managing money that you're worried would go spend the money and the inheritance right away, or maybe they have a medical disability that you want to leave in trust so it doesn't disqualify them from any government benefits that they're on, or maybe they have some sort of substance abuse problem, but you still want them to have an inheritance, but you don't want that inheritance to be squandered on illegal activities. So those are some other situations where you could use a trust to protect those people from themselves, and alternatively designate a bank, trust company, or somebody that you trust to manage that inheritance for the respective beneficiary.
Okay. And we had a situation years ago, Richard, where somebody had passed away. You know, the patriarch of the family had passed away, and so leaving to his 3 adult kids, you know, part of his inheritance, or part of his, you know, what he left behind, of course. And one of the adult children, the husband was incapacitated and was getting state benefits, you know, for life because of his disability. And so she didn't want to get that inheritance at all because it would have disrupted the disability benefits that the state was paying. And it would have been extremely disruptive to just try to get those back on board later. So she just said, no, I don't want it. You know, give it to my siblings instead.
Yeah, there are, though, special trusts that can be set up in that scenario to protect her to still receive it. But that's the conversation for
Yeah.
today.
Yeah. And that's more of a permanent trust, which is a whole separate legal entity separate from her, but that could help.
Yeah, there's
address
special
that.
Medicaid trusts that you can create too.
Yeah. Okay. So a couple of things I want to touch on also. You know, in estate documents, there's the will, you know, a trust, but there's also the medical power of attorney, financial or durable power of attorney. Could you talk about those just a bit?
Yeah, so those are the documents that we use to plan for incapacity. So those documents provide who makes decisions for you financially and medically if you can't do so any longer yourself. So the people that you designated in those documents can now act on your behalf and interact with your banks, your financial institutions, custodians, medical care providers, doctors. Those people can act on your behalf and take care of you in that scenario.
Okay. And once you pick somebody, if you pick somebody today and something changes, you can always change that, right?
Yes, as long as you still have your mental capacity. But if you don't have mental capacity to understand what you're signing, then you can't change it anymore.
Okay. And then the durable and financial, what does that specifically do in those estate documents?
The durable power of attorney is a very broad document that gives the agent you designate essentially the authority to act as though they are you. It is valid unless you revoke it through the duration of your life. So once you die, the durable power of attorney expires and is no longer valid. But what it allows for is your agent to make financial decisions for you with respect to a whole array of issues, such as with your banks. If you're in a lawsuit, they can interact with your attorney as though they can deal with people who are giving you issues relating to credit claims. So it's a long list of authority and powers that you give to a person to make decisions for you.
Okay. So we had something recently where that came into question, where there was the durable power of attorney, which the person could sign for the bank accounts and that. And the woman who was now having some health issues was now in a living facility, not permanently, but she had to go into a facility while she was recovering from surgery and that. So the person that she had designated to be that durable POA who could sign the bank accounts and pay the bills and that started to do that for her, but then realized it was a very, very time consuming process. And so it became difficult for that person who was acting as the POA, it became really difficult for her to keep her own life intact and now do this other thing for this other person acting as the durable POA signer. So she revoked it. She said, I don't want to do this anymore. You've got to find somebody else. And at this point, the woman who was now in this living facility now had to find somebody else. So she had planned ahead and designated somebody, and that all seemed like it was going to be great. But now she's in a spot where that person revoked, and there isn't readily somebody else to step in to take over that role.
Yeah, in that situation, she is in trouble because she's going to have to find a conservator now to be appointed to manage those accounts, because the durable power of attorney lacks an agent, unless she can still understand what she's signing and create a new one.
Yeah. So there's there are people called fiduciaries out there that I think will kind of step into a situation like that. They're paid to do that. That is what they do. It's a service they offer. And so that may be the likely place for her to go now that that family friend has rescinded her consent to be that POA for her.
Yeah, so there's private fiduciaries who are regulated by the Supreme Court who could fill that role. And then there's also banks and trust companies that will do so as well.
Okay. Okay. So we've touched on a lot. Things that we haven't really touched on, Richard, that really come into play when you're having those initial conversations with people about estate documents. They're asking you questions and they're helping you understand, where they are, what they're doing. What are some of the common things you hear from them that maybe be helpful to talk about now?
Yeah, one common theme is they want to make sure that assets that they leave to their kids aren't squandered or mismanaged by maybe a spouse or somebody in their life who's exercising bad influence over one of their kids. So a common theme is they want to protect that inheritance for their children.
Okay.
What we recommend in that situation is to create asset protected subtrusts for each respective beneficiary. What that allows for is when the parents die, each child will receive their inheritance in their own separate trust. And the benefit to the child is if they are ever involved in any sort of lawsuit, bankruptcy, or divorce, then that inheritance is protected as long as it remains in their separate trust. Now, if they were to take it out of their trust and put it into a joint checking account with their spouse, and then they get a divorce, it loses that asset protection, or it becomes more difficult to prove that that was intended to be separate property. So that's definitely a common theme that a lot of people are concerned with, is providing asset protection for their family and loved ones. I'd say the most common.
So the subtrust you mentioned, say there are 3 kids and then there will be 3 subtrusts. Are those sometimes called beneficiary trusts?
Yeah, the common term, beneficiary trust, asset protected subtrust, inheritors trust. Those are some terms used to identify.
Okay, the term is less important, or the title of it is less important than what it says in the trust, it sounds like.
Yeah.
Okay. Yeah, we had a client not too long ago whose parent died, and the client received a beneficiary trust, and it seemed like part of the thought process there for mom when she created the structure was to help protect the assets from the the daughter's husband.
Mm-hmm. Yeah, that's a very common scenario, is the parents worried about the influence of the spouse and diverting those assets, not necessarily for their child's benefit, but for the benefit of this spouse that is potentially causing issues.
Yeah. And so if you do that, I do have a question about that maybe you can touch on, because, she had this beneficiary trust. And so she was the one who was in charge of that trust. She made decisions on that trust. But within a marriage, there can still be a lot of pressure and influence, even though legally the trust says that, the daughter was in charge of this. There can be a lot of friction in the marriage, and that because of this money now that wife solely controls, and it can be a difficult situation. So there are also corporate trustees that could step into that role, where then wife is not really in control, right? Now it's up to the bank or the trustee that it's their decision, and they're following what mom said in those documents. And now husband and wife, it kind of removes that pressure, it would seem like.
Yeah, a corporate trustee would be a great idea in that scenario, because it takes the wife out of the picture, it takes husband out of the picture. And if the corporate trustee feels that a request for a disbursement is a legitimate request that should be honored, then they can make that distribution. If they feel like there may be something wrong, or that the money is not being used for a good purpose, then they can deny the distribution and continue to manage the money.
Okay. Yeah. And so the way the corporate trustee would administer that and dole the dollars out, it's based on the language in the trust that mom wrote, right?
Yeah, most oftentimes it's based on the health, education, maintenance, and support of the beneficiary.
Yeah.
So if a potential distribution falls into any one of those four categories, then the trustee would presumably distribute the money to the beneficiary to be used for that purpose.
Okay.
Now you could write the trust to be even more restrictive than that, and just make it what we call a pure discretionary trust, where the trustee has the sole authority to decide whether or not to make a distribution. And that's much more restrictive with respect to the beneficiary's needs, because now you're throwing everything on the trustee. So sometimes people don't want to be that onerous on family members or loved ones.
Yeah. Well, you just never know. Never know. But, parents always want to try to help the kids, even though the kids are maybe 50, 60, 70, 80 years old.
Yeah.
But that's just how it is. So what about, a living trust and a living will? You hear those terms in estate planning. What does that really mean?
Yeah, sometimes people confuse the two. They'll say, I need to get my living will prepared, thinking that it's a document to transfer property on death. A living trust is the document that you would use to provide transfers of assets upon the death of the trust maker, like we discussed earlier. The difference with a living will is a directive or a set of instructions that you provide to your doctors on how you want to pass away if you're in a terminal and vegetative state.
Okay.
You are telling the doctors that in that scenario, you don't want normally to be kept alive by machines, feeding tubes, ventilators, and so forth. You'd rather pass naturally and not go through that end of life process on those intensive healthcare procedures.
Yeah. Okay. Okay. Thank you. And let me see what else I might have here. So I do have a question for you on, we talked about that beneficiary that deed of trust on real estate. But what about a business? How does that, someone owns a business, how does that fit with their whole estate planning process in terms of how you would title the ownership of actually who owns the business?
A business should, in my opinion, be owned by the trust. That way, it avoids the probate issue, and there's a smooth transfer of control upon the business owner's passing. Now, there may be certain businesses where you cannot have a trust as the owner, and normally that's in the context of the business owner providing professional services.
Okay.
They're prohibited from the state licensing agency that oversees that professional service. But, it's important that the trust is the owner of a business, especially businesses that are successful. I mean, I've had personal experience in a probate context where a man died who owned a business that was very labor intensive, time intensive, and it needed somebody to act right away on his death. Due to the fact that he didn't have the business in a trust, there was nobody who could assume authority to act on the business's behalf until a personal representative was appointed by a probate court who could then step into the shoes of the business and act on its behalf, which caused a lot of value in the business to be lost. So if a trust had been set up as the owner right away, there would have been smooth transfer of control from business owner to successor trustee, and the business wouldn't have lost value.
Yeah. And you bring up a good point that sometimes when a person dies, that company really depends on that person being around, and the value that's there before the person dies might be pretty substantial, but it can very, very, very quickly erode.
Mm-hmm. Yeah, so that's why it's important too to find whether it's a key employee, maybe somebody who's worked in the industry that the business is involved with, but a person that knows how to run the business and will protect its interests after the death of the owner.
Okay. So Richard, what about other other things maybe we haven't touched on, or maybe some just examples or stories of estate planning you've done with clients in the past, and maybe some of the surprises they had, or some of the just some of the experiences that you've had going through this that's been helpful to a family as they go through this, say, for the first time.
Yeah, most of the things that I have seen that are bad happen unexpectedly after someone dies and they haven't done any estate planning. Going back to my business example on whether or not the trust should be an owner, in that context, we had a minor child that the family discovered the father had that they didn't know about. So it was very difficult to get somebody appointed in that situation to represent the interests of the business. And then on top of that, they now discover that there's another person who's going to inherit an interest in the estate that they've never met before, who's very young. And it made it difficult to do things as far as getting a personal representative appointed, and then setting up the minor child in an efficient manner to transfer what he was due to inherit. So that happened in the business context. I've also seen stories where we have helped people, like you were talking about earlier, Armando, that had special needs that they didn't think they could leave an inheritance to a family member with a disability, but they were able to do so through setting up a trust to benefit them. And those are some of the common scenarios that we dealt with. And then on top of that, from an asset protection standpoint, we've had clients that have come in here with large, judgments issued against them for, reasons that weren't necessarily their fault, but their parents didn't want to disinherit them from their estate. So we were able to set up one of those asset protected sub-trusts for that beneficiary so they could still receive an inheritance from their parents.
Okay, good. Well, let me just recap a little bit. You mentioned in the basic estate planning documents, really what people should expect is a will, a trust, a medical power of attorney, a durable or financial power of attorney as well in there. The trust, making sure the beneficiaries are correct in anything that has a beneficiary, like an IRA, a Roth IRA, 401k, life insurance beneficiaries. We didn't really touch on that much, but those do also have a beneficiary, and those beneficiaries need to be correct as well. For the home, you mentioned that a beneficiary deed might be an easy, maybe even a lesser expensive way to transfer that home, the personal residence or other real estate to whomever they want to transfer that to. You just got to get that in ahead of time. We also talked about a beneficiary deed or other type, a beneficiary trust or other type of a trust, so that if there's a concern that when the wealth gets from, say, the parent to the adult child, that the adult child can enjoy the benefit of having those assets, either because they are now in a trust that person can themselves control, or that maybe there's a corporate trustee that is going to control those assets and administer them for the benefit of that adult child. And that's a corporate trustee, maybe it's a bank or a trust company itself. So that's a way to do that as well. If there's going to be maybe undue pressure coming from the adult child's spouse, or there's something else, maybe they've got a disability, get estate benefits, and this might allow them to have a whole separate trust to receive those assets that parent wants to give to adult child without disrupting any state benefits or disability benefits that might be coming in.
Yep.
Right.
Yep. Those are all good reasons.
Yeah, good. And then the will, you talked about, what was that term you used for the will? That a holographic will, that's what it was, where sometimes they might get these nice, neat papers drawn up by the attorney, they sign and date them and it's all good, but then they might make notes on that, handwritten notes, or get a whole separate sheet of paper and in their handwriting write a will, and then it creates more of a problem.
Yeah.
It's not clear which will is what did they really want before they passed.
Yeah, and was it a valid, what we call holographic codicil? And yeah, it's just something that could cause a lot of issues if that were to be contested among family members.
Yep. And then you also talked about probate, that if it's not clear, probate can really drag out, can be a costly effort to go through. But if it is more clear and it is documented and written up and it's nice, neat, and done well, then probate might be a very shorter process. But I think when you started, you said something about what is the purpose of these estate planning documents? It's so that while you're alive, you can decide who is going to get the stuff that you own and control today. And you also decide who's going to,
how they're going to get it.
Yeah. Yeah. What do they get? How do they get it? When do they get it? But that's all part of what those documents do. And that's how you're helping families to document that, so it's least disruptive when the person actually does pass away.
Exactly. Yep. We're trying to make it easy on them during their lifetime and then easy on their family after their death.
Good. Okay, Richard. So any last thoughts on, well, maybe we didn't touch on something, or last thoughts you want to make sure that anybody listening and maybe they haven't updated their estate documents,
Yeah,
maybe they've done them?
I would say the number one reason people come in to see us to get an estate plan created is typically they just experienced a bad personal experience in their own lives with somebody who died recently that hadn't had an estate plan prepared. And now they don't want to put their own family through that situation.
Yeah. So if somebody wants to get a hold of you and have a conversation with you, Richard, what's the best way for them to reach you?
Just my direct phone number here at Keyt Law, which is 480-664-7472. Or you can shoot me an email as well at rck@keytlaw.com. And then
Okay.
we also have a website, keytlaw.com, with plenty of information on there.
Great. So let me just repeat that. You said telephone 480-664-7472, right? Or shoot you an email, rck@keytlaw.com, KEYTLAW.com.
Yep.
Okay. Okay, great. Richard, this has been really helpful. Thank you so much for sharing your expertise. I'm hoping that people will hear this and hear what you've said, and that'll be enough for them to give you a call to maybe ask you questions or ask you to help them with their own estate planning.
Yeah, thank you so much for having me, Armando. I enjoyed the conversation, and looking forward to helping anybody out there who has questions on estate planning and what they need to do to get their affairs in order.
Great. Excellent.